Can you sell a car, house, or property that you don't even own? In Hanafi Fiqh, the answer is more nuanced than you might think. Today, we'll explain this fascinating case from Al-Quduri, including the role of the Fuduli seller, the owner's approval, and when the sale becomes valid or void.
The scenario is that a person, he sold the property of another person. He has nothing to do with that. He has no ownership. He has no share, in that property. He just sold it to a person. For example, there is a car. Yeah, we have this car, and the owner, its owner is Zaid. So here, Umar, Umar, he sold this car. He is buyer. So he is selling it. So he is buyer. To who? Bakar. So Bakar is mushtari. He is the client. Zaid, the owner. So he is supposed to sell it. To sell the car to Bakar, right? Because that is his ownership. But what happened? Umar, a third person, who has no concern with this car, he just make a transaction on this car. He make a transaction. He make a contract, with Bakar. Got it? And he said, I sell this to you on 5,000. Yeah. So now is this sale is concluded or not? Is it valid or not? So we learn that the person, he cannot sell something that does not belong to him, that he does not own it. So if he doesn't own the thing, he cannot sell it, right? So Umar has no right to sell it, but he did. Yeah. And Bakar, he paid him the money. So what to say? So here we have three things. One, ba'i', second, mushtari, the seller, the third, sold item. This is the third thing. And there is another element, which is the owner, Zaid. So here we say that if the owner, Zaid, if he allows this sale, if he is agreeing, when he was told that your car, is sold. So what you say? Would you ratify this? Would you allow this sale or not? So he said, okay, I allow this. Yeah. So in that case, the Bakar who paid this money to the Umar. Yeah. So Umar, he will be responsible to pay it to the Zaid. He is responsible. If the Bakar, he did not pay yet, so he directly pay it to the Zaid, because Umar is a third person. He has nothing to do with this. Actual owner, is Zaid. So he is the actual, party. Got it? And we say that Umar is just a representative of Zaid. This also rests on his permission. If Zaid permit this sale, so we say that Umar acted on behalf of Zaid in selling this car. In selling this car, he acted as, he was just an agent. So he is the agent of Zaid in selling this car to Bakar. So that is the, and in Arabic we call this third person who is not owner, we call it Fuduli. Yeah, that is the term for such person. Yeah. And if the Zaid, the owner, he does not allow this sale, so it is invalid. Got it? It is invalid, and Umar has to return the money to the mushtari. Yeah. وَمَنْ بَاعَ مِلْكَ غَيْرِهِ ومن باع ملك غيره بغير أمره فالمالك بالخيار إن شاء أجاز البيع وإن شاء شاء فسخ وله الإجازة إذا كان المعقود عليه باقيا والمتعاقدان. I explain this terminology to you. the contractors, the buyer and mushtari. والمتعاقدان بحالهما. Yeah. وَمَنْ بَاعَ مِلْكَ غَيْرِهِ, and whoever sells مِلْكَ غَيْرِهِ, the property of another person, بِغَيْرِ أَمْرِهِ, without his authorization. بِغَيْر means without his command, without his authorization. So a seller, he can authorize his agent. No? He can authorize him. We call this agent wakil in Arabic. So we can say that you are my wakil, so I authorize you to sell this property. Right? But here case is that the person who sells the property, he was not authorized by the owner. So in that case, bay happened. This sale, it is concluded because there is ijab and there is qubul. Only thing is that he is not able to deliver it. The seller, this Umar, he is not able to deliver this car to Bakar because it belongs to Zaid and it is with him. How he can deliver it? So because of this, issue, this bay becomes suspended. This bay is mawquf, stopped. On the permission of the owner. فَالْمَالِكُ بِالْخِيَارِ. So the owner has the option, in sha'a, if he wishes, ajaza al-bay'a, he ratifies the sale. Wa in sha'a, and if he wishes, fasakha, he rescinds it. Got it? وَلَهُ الْإِجَازَةُ, and he has the right of ratification so long as al-Maqood Alayh, the subject matter. Maqood Alayh mean sold item. Maqood mean upon which the contract occurred. So this is Maqood. So Maqood Alayh, this whole word, it means mabi', and you know that mabi is sold item. If the sold item is there, mean it has not perished. For example, if that car upon which the Umar he made the contract, he sold it. If the car it perished, totally perished in accident, so in that case the buyer, he is not able to deliver it. Even he is not able to permit the owner, I'm talking about the Zaid, the owner, he is not able to permit this sale. How can he permit it while the car is no more? So in that case, we say to the Umar, who is the seller, we say to him, return the money to Bakar, because this bay cannot be concluded, because mabi is no more. No? Mabi is just like the rukan of sale. Mabi and saman both. Without mabi, there is no sale. So the owner, he has the right to allow the sale إذا كان المعقود عليه, when the subject matter, mean the mabi, باقيا, it is existent, it remains in existence. والمتعاقدان بحالهما, while the contracting parties, they remain as they are. Three things are important here. Actually four. First is the seller, Umar, and second thing is Bakar, the mushtari. The third thing is the sold item, car, and the fourth thing is the owner. Yeah. So for the allowance of this sale, we need that these three elements, buy, mushtari, and the sold mabi', the sold item, they must be in existence and on their state. So if one of these three, it perishes, the sale becomes nullified. It becomes void. Because for example, if the mushtari, he died, he died. So an owner, Zaid, he allows the sale, but allow to whom? He allow for whom? While the mushtari, he has passed away. Right? So that's why we said the three things, they are important, buy, mushtari, and mabi.
So, can you sell what you don't own? Now you know the Hanafi ruling. For more clear explanations from Al-Quduri and Hanafi Fiqh, subscribe, like, and share this video, and join us for the next lesson.